So what is family preference immigration? Who qualifies? And what are requirements? Welcome to U.S. Immigration Simplified. I'm immigration and business attorney Ronald Lee. Family preference immigration allows U.S. citizens and lawful permanent residents to sponsor certain family members who do not qualify as immediate relatives. These petitions are subject to numerical limits, resulting in longer processing times compared to petitions for immediate relatives. Family preference categories. The U.S. Citizenship and Immigration Services divides family preference into 4 categories based on the relationship to the sponsor. F1 First Preference. Who qualifies? Unmarried sons and daughters 21 years or older of U.S. citizens. Derivative beneficiaries. Eligible children of the principal beneficiary. F2 Second Preference. Who qualifies? F2A Spouses and unmarried children under 21 of lawful permanent residents. F2B Unmarried sons and daughters 21 years or older of lawful permanent residents. Derivative beneficiaries. Eligible children of the principal beneficiary. F3 Third Preference. Who qualifies? Married sons and daughters of U.S. citizens. Derivative beneficiaries. Spouses and children of the principal beneficiary. F4 Fourth Preference. Who qualifies? Brothers and sisters of U.S. citizens. Sponsor must be 21 years or older. Derivative beneficiaries. Spouses and children of the principal beneficiary. In terms of numerical limits and priority dates, there are annual caps. Each family preference category has a specific number of visas allocated annually. For example, the F2A category often has higher availability compared to F4. The priority date, the date that Form I-130, Petition for Alien Relative, is filed, determines the beneficiary's place in line. The Visa Bulletin, published monthly by the Department of State, it shows the cutoff dates for each category and country of origin. Beneficiaries must wait until their priority date is current to proceed. What are the steps in the family preference process? Step 1, file Form I-130. The purpose of it is to establish the qualifying relationship between the sponsor and the beneficiary. In terms of required documents, proof of the sponsor's status, relationship document, for example, birth certificates or marriage certificates. Step 2, approval and visa processing. After USCIS approves Form I-130, the case is sent to the National Visa Center for further processing. Beneficiaries must wait for the priority date to become current before proceeding with visa applications or adjustment of status. Step 3, consular processing or adjustment of status. Consular processing is for beneficiaries outside the U.S. They must apply for an immigrant visa at a U.S. embassy or consulate. Adjustment of status for beneficiaries already in the U.S. They can apply for a green card through Form I-485 if eligible. Step 4, attend visa interview. The beneficiary and any derivatives must attend an interview where eligibility and admissibility are evaluated. If you need help with your family preference category petition, text me at 312-804-1386 or email me at ronald@rdllawgroup.com.